Order. The August 8, 2023 City of Daytona Beach Special Magistrate Proceedings. At the outset, I reviewed our minutes of July 11, 2023, approved them, and executed them. Do we have any announcements before we proceed with this morning's proceedings?
Yes, sir. Page number 8, case number 28, SMG 07-23-173, 327 North Caroline Street is in compliance 8/3/23. Page number 12, case number 43, SMG 07-23-179, Seaman Place parcel, compliance 8/3/23. And page number 13, case number 45, SMG 07-22-202, 701 South Atlantic Avenue, compliance 8/3/23. That's it.
Okay. Will those representatives for the City of Daytona Beach who will be testifying at this morning's proceedings please stand and be sworn?
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
All right, we have a couple of cases that for various reasons we need to take out of order, so let me go to case number 17.
I don't know, 17?
Michael A. and Barbara M. Thrower. Is there anyone here for the respondent? I take it you're not? Very good.
By the way, since we're on 18 is in compliance, as you can see. This morning I went and took a picture.
Did I do that? Oh my God, I did do that.
That's all right. So case number, while we're here, case 18 is in compliance?
Case number 17 that you called, I believe.
Okay, now I'm getting us all totally confused. I mistakenly called case number 17.
Correct.
Okay,
Case number 17 is in compliance as of today.
very good. Is there anything we need me to do? It's in compliance. Okay, thank you.
you.
Case number 18, SIG Global Family Limited Partnership. And it would appear Ms. Gao is here on behalf of the respondent. This was continued from our July hearing for the determination of a compliance date. So, Mr. Inspector, how much time do you think should reasonably be required for the respondent to come into compliance?
Inspector Jean-Baptiste, City Certified Code Inspector. This case has been open for over a year now, and you're well aware of the circumstances of this case. However, up to recently, I have not seen that a permit was obtained for any of the work to start. As such, staff is recommending to set a compliance date by next cutoff.
All right, next cutoff, it would appear to be September 6, 2023. What say the respondent?
The permit has not been issued, it has been applied for. So the permit has been applied for in permits and licensing, it's available online. The city had initial permit review comments. They want a topographical survey. You remember this one, the retaining wall seems to benefit the off-site owners by keeping their grading up. So the city has asked for a topographical survey to show that when the wall is removed, how they are going to grade the property back down so there's not a drop. And to make sure that drainage on our site is not going to go off-site. That will be easy for us to show because it's all going to drain into us, but we still have to check the boxes. To get the topographical survey, I think is going to be at least 3 weeks. So I would request the cutoff following September, but we can provide an update on where that is and really push for that. I know it has been lingering.
So 3 weeks to get the topographical survey, then you submit the survey, what, to the city for their review of your permit application?
Correct.
And just out of curiosity, assuming that you're removing the wall, do we have any idea as to how much time that would require?
The contractor says that should not take long at all, about a week of full work.
And you are doing a topographical survey as to your property, or your property and the neighboring properties?
Our property to show that our drainage does not go off-site. Again, seems silly, but it's a technical requirement to make sure that our drainage will not impact off-site owners based on the scope of work. I think it will be exactly the opposite based on,
Somebody thinks your drainage is going to go uphill and climb over a wall?
they have to prove it won't when the wall is gone.
And it's just these neighboring properties that the topographical survey concerns itself with?
Yes, the city asked for a topographical survey with drainage arrows marked to show the flow of water. Does not go off-site. It will come into the site.
Okay, which brings me back to my other question. So assuming it shows that your drainage is not going to airlift itself into the neighbors' backyards, how much time would be required to remove the wall?
A week.
A week. All right, then I'm going to order the respondent be in compliance by October 4, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 19, SIG Global FLP, 509 East International Speedway Boulevard.
Mr. Magistrate, case 18 is the same as case 19 and the same as case 20, as in time span.
So all three of these are going to be subject to this topographical survey that we just talked about? And without getting too far into the weeds, whatever the violations are for 19 and 20 will be cured with the removal of the wall? And I guess a few other miscellaneous things that look pretty minor.
Correct, sir.
All right? Okay. Does that sound correct to you, Ms. Gao?
That is correct, yep.
All right, based upon our inspector's report, based upon respondent's counsel's apparent consent with regard to cases 19 and 20, I'm also going to order that the respondent be in compliance by October 4, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter.
Thank you.
Okay.
And I also have case 35.
Case number 35. Vishnu Limited and MMA Shantoshi. All right, this was continued from the May hearing for a progress report and a determination of a compliance date. Which of you wants to give me a progress report?
I can go first.
Go right ahead.
So since the last hearing, they've continued enclosing the walls of the existing structure. They have one floor left, the top floor to go through for the enclosing of the structure. Talked to Inspector Yates this morning. There has been some graffiti activity on the site recently, so we need to work to get that removed.
There's been some what?
Graffiti on the front wall. So we will work to get that removed. We talked about that this morning. They've met with the county a few times to discuss the allocation of a license agreement for parking adjacent to the site in the county parking area for the hotel. They're undergoing site plan review, and they are going through a variance process for some of the non-conforming site criteria. Inspector Yates and I talked this morning. He does want a more detailed construction schedule on when we think completion is. The initial schedule we gave, he has some concerns that it won't be met, and so I told him I'd follow up with them to see if that needs to be revised, but that is where we are since the last hearing.
As far as this particular notice of violation is concerned, what is the work that's contemplated? I mean, I can see you're remodeling a whole motel.
Right.
Essentially, that is the work that needs to be done. The building either needs to be removed or renovated for it to come into compliance. But they are, as she said, moving along as scheduled, and they continue to move forward. So the city would be requesting them to come back for a progress report in December.
You guys aren't going to stop between now and December, are you?
I don't believe so.
Very good. Okay. Then, based upon our inspector's recommendation and the apparent consent of the respondent, I will maintain the status quo for this particular matter and schedule it for another progress report at our December 12, 2023 meeting. Very good. Good luck to you.
Thank you.
Okay, case number 34. Mark A. and Julie L. Walshager. Good morning.
Good morning.
If you would state your name for the record.
Corey Brown with Storch Law Firm, 420 South Nova Road, Daytona Beach.
All right, I have that this matter was continued from our May hearing for a progress report and determination of compliance date. Are you giving me the progress report?
I do have a progress report. We are still waiting on the sheet piling, and we got the permit extended until October 30th. So as soon as we can get the sheet piling in, the contractor's ready to do the work, put it up, be done.
What is sheet piling?
It's slabs of concrete. Is that correct?
Basically, yes, that's the easiest way to explain it. So it'll be a wall replacement. It'll be their new seawall is the easiest way to say it. Given the current timeline, I feel like we should be able to set a compliance date for November, for the November cutoff at this point.
So you're waiting on more slabs of concrete that are going to be installed, and then when you're done doing all that, then your client will have himself a new seawall, theoretically. Okay?
I don't know when exactly the sheet piling is going to be here. It was supposed to be here by sometime in August. But I think the best we can do is just hope we'll get the product and have it done by the end of the extended permit date, which is October 30th. So November would seem in order to give you an update.
Now, what sort of things, and this is more curiosity than anything else, what sort of things is the respondent expected to do in the interim until his wall's finished, as far as securing whatever he has or keeping it from leaking, bleeding, or spilling?
That's what those P-trap bags are for. Those are the temporary mitigation measures that were approved by DPBR and the Florida Department of the Environmental Protection as well. So they have done their temporary. We're just waiting on the final delivery of materials.
And as it stands, you're expecting delivery of these things in October.
August.
I'm not exactly sure when it'll be here yet. I mean, I think we're just waiting on a week-by-week basis to see when it comes in. Several months ago, I was thinking it was going to be here in August, and it hasn't gotten here yet. So we got the extension to end of October. I can try to get you more information about estimate on the date we'll get it, but I just don't think we know the date we're going to get it. There's such a lack of supply of this product throughout Florida that we're just kind of at the mercy of the supplier to provide the product. But I know that the contractor's ready to go as soon as he gets the stuff. So.
So when's your new owner moving in?
I think that they're moved in.
Okay.
Yeah, I mean, I think that's one of the reasons. Well, even
They've
if they
been working
weren't.
on the driveway. The driveway's not done yet. That's why I
Okay.
asked.
Unfortunately, they're going to have to reconfigure that. They just they failed the inspection for that. It's too close to the road.
Okay.
Not that that's relevant to this case, just information.
No, but before I go putting something all the way off to November, I want some confidence that it's actually going to happen. And I don't mean to
No, I can understand.
cast any aspersions on your client. If it's an empty house and somebody were saying, put it off till November, I'd say, I don't know about that. If, on the other hand, someone's going to be moving in, and I can reasonably assume they'd really like to have their seawall in place sooner rather than later, then maybe I don't have a problem with it. So is the place occupied yet or not?
Honestly, I don't know.
Okay.
I thought it was, but if I see right now, I see storm shutters up, and apparently the driveway's not.
I was going to say, I do not know, but I have seen no indication that it would be occupied.
I will say that a storm comes through, it'll blow out all that sand and undermine the house again. So I know that it's super critical we get it up as soon as possible.
Yeah.
All right, well, if the parties are stipulating to November, that's fine with me. Is that what I'm hearing?
Yeah, I'd like to ask for a November compliance date, though.
Works for me.
Okay. Based upon the stipulation of the parties, I'm going to go ahead and order the respondent to come into compliance by November 14, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Okay, good luck to you.
Thank you.
All right, the next case is case 38.
Mr. Vakelchak, can you clarify the compliance date or the cutoff?
I'm
You just
sorry.
said-
I'm going to go ahead and order that the respondent be in compliance by November 8th, thank you, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter.
Thank you.
You got that, Counselor? Yes, sir. My mistake. Case number 38, Be Good Developments LLC. All right, we have Mr. Hopkins present. I guess he needs to be sworn.
You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
I have that this is continued from a June hearing for a progress report and determination of a compliance date. So are you giving us a progress report?
Yes, I am. We've made application to the building department downstairs. It's been received, and it's currently under review. As soon as the permit is issued, we're set to initiate redevelopment of the structure. And at present, there were some other violations and appearance standards and so forth that have been brought into compliance. So the only outstanding item right now is issuance of a building permit. So we continue redevelopment of the structure.
And when do we expect permits to be in hand?
I would assume sometime this month.
Okay, what say the city?
We agree with basically everything they've said. I'd like to have him come back in October for a progress report, at which point hopefully he will be able to give us a compliance date.
Wow, is it really taking off for the summer or something? Okay, so we're going to October for a progress report.
Yes.
Okay. So once you have your permit, then what? We have major construction to be done?
We estimate probably about 6 weeks' worth of work to do on the interior, but there's also going to be a companion site plan permit for the exterior of the property. So this violation involves the building itself and the grounds and appearance standards. The request that we have before the city right now is for a building permit to renovate the building and the interior. We have to also process a site plan to improve the exterior of the site. It's a separate process and not really part of this violation, but I just want to be clear that there's a two-part process to this.
Okay. So in any event, so the city suggests we return for a progress report at our October meeting?
Yes, sir.
You have any objection to that?
Not at all.
All right, then with regard to case number 38, I will put this matter on our October 10, 2023 meeting for another progress report and perhaps the determination of a compliance date. Okay, good luck to you.
Thank you very much.
Case number 1, Albert Campbell. Anyone here for the respondent?
Morning,
Good morning.
Inspector Bostwick, credentials on file. All right, this case was field generated, opened back up on May 1st of 2023 for overgrown vacant lot, trash and debris. Those are some current photos, I believe, from yesterday. Compliance was due by May 14th. Last day of reinspection was yesterday. Result non-compliance. I met Mr. Campbell this morning here in the auditorium, and he said he will have it finished up in the next week or so. So staff requests finding a non-compliance with compliance due next cutoff.
All right, based upon our inspector's report, I find the respondent in non-compliance. In order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 2, Stephen Alexander Steele. Anyone here for the respondent? Yes, sir. If you would please state your name and be sworn.
Stephen Steele.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Mr. Steele, do you agree this violation existed or occurred as stated in the notice of violation?
That's right.
All right, I find the respondent in non-compliance. Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance?
Next cutoff.
City is suggesting you ought to be able to have this fixed by September 6th. What say you to that?
Okay. Yeah, I've been working trying to get this. There's a big boat that's on the lot there. The other items have been removed, except for the truck, which is the neighbor's.
Well, that has to be moved also.
Right, the truck hasn't been moved. The big boat hasn't. I've been trying to get a company to get there to remove the boat that had been left on the lot.
Is the boat on a trailer?
No, which is kind of the
On
problem.
blocks?
Yeah, it's on the stilts there.
That'll be a bear.
Yeah. So I've been working with various disposal companies, having them to come out to try to see about removal. But it is a rather large boat. So I've been having time some folks out there to attempt to remove it.
All right, well, I have a sad, long history with boats, so if you get jammed up on the boat, get in touch with this gentleman, let him know what's going on, let him know what efforts you put into getting it fixed, and satisfy him that you're doing everything you can to get it rectified. That having been said, I'll order the respondent to be in compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. And once you get everything taken care of, make sure you call him to do a final inspection. It ain't over till he comes out, eyeballs it for himself, then he puts a notice of compliance in the file, and then you're done.
Great. Thank you.
Good luck to you. And again, you get jammed up on that boat, keep him posted as to what's going on.
Okay, very good.
All right, have a good day. Case number 3, Darius and Ruby Fletcher. Not seeing respondent, what say the city?
Well, this case was field generated and opened on May 17, 2023, on trash and debris left in front of the property. First notification was on May 22nd of 23. Compliance was due by June 3rd of 2023. Last day of reinspection was August 7th. Result, non-compliance, no contact from the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
All right, based upon the testimony of our inspector, noting the absence of the respondent, having looked at the photographs, I find the respondent in non-compliance and order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 4, Alik Afghani Trust. Anyone here for the respondent? Not seeing a respondent, what say the city?
All right, this case was field generated, opened on May 16th of 2023. Overgrown vacant lot, trash and debris. First notification was on May 20th of 23. Compliance was due by the 31st. Last day of inspection was August 7th. Result, non-compliance. I've been in contact with the owner. He was working on the property, and he should be cleaned up by the end of this week. Staff requests a finding of non-compliance with compliance due next cutoff.
All right, based upon our inspector's testimony and having seen the photographs presented, I find the respondent in non-compliance and order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 5, Willie Mae Lane. Anyone here for the respondent? Not seeing a respondent, what say the city?
All right, this case was field generated, opened on May 24th of 2023, overgrown vacant lot, trash and debris. First notification was on May the 24th, property was posted. Compliance was due by June 5th of 2023. Last day of reinspection was August 3rd of 2023, result non-compliance. No contact from the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Based upon our inspector's testimony, noting the absence of the respondent and the photographs presented, I find the respondent in non-compliance and order the respondent come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 6, Chucky D. Edwards. Anyone for the respondent? What say the city?
All right, this case was field generated, opened on May 24th, 2023, overgrown vacant lot, trash and debris. First notification was on May 24th of 2023. Compliance was due by June 6th of 2023. Last day of reinspection was August 3rd of 23. Result non-compliance, no contact from the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Based upon our inspector's testimony, noting the absence of the respondent, based upon the photographs presented, I find the respondent in non-compliance and order the respondent come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 7, George R. and Angelina M. Alves. Anyone here for the respondent? Not seeing a respondent. What say the city?
And this case was field generated, opened on May 31st of 2023, overgrown vacant lot, trash and debris. First notification was on June 19th of 2023, property was posted. Compliance was due by June 28th of 2023. Last day of reinspection was August 7th of 2023. Result, non-compliance. No contact from the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Based upon the testimony of our inspector, noting the absence of a respondent, having considered the photographs presented, I find the respondent in non-compliance and order the respondent come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 8, Randy Rocco et al. And Thomas Bollock. Anyone for the respondent? Not seeing a respondent, what say the city?
This case was field generated, opened on June 14th of 2023, overgrown vacant lot. First notification was on June 15th, property was posted. Compliance was due by June 25th. Last day of reinspection was August 7th, result non-compliance. There's been no contact from the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Based upon our inspector's testimony, noting the absence of the respondent, having considered the photographs presented, I find the respondent in non-compliance and order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 9, Earl McCrary III. Not seeing a respondent, what say the city?
All right, this was a citizen's complaint, came in from the city manager's office. Case was opened on June 21st of 2023. Multiple vehicles, trailers parked on a vacant lot, overgrown landscaping, trash, and debris. First notification was on July 5th of 2023. Compliance was due by July 16th of 2023. Last day of reinspection was August 7th, result non-compliance. I haven't spoken with the owner, but I have been speaking with the individual who's parking all those vehicles, and he's trying to clean them off. Staff requests a finding of non-compliance with compliance due next cutoff.
Based upon our inspector's testimony, noting the absence of the respondent, having considered the photographs presented, I find the respondent in non-compliance and order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 10, Mystic Oak South, LLC. Okay. And we have a Zoom appearance.
Yes, I'm here.
We will need you to turn your camera on so we can swear you in, please.
Yes, sir, if you would please state your name.
Austin Lovin.
And what is your affiliation with Mystic Oak South LLC?
I actually don't believe that's not me.
Okay.
What case are you here for?
Well, it says case number 10, but I'm here for it's SMG's 08-23-200.
Well, I have that listed as Mystic Oak South LLC.
What's the address?
Is that right. Is it the 2721 West International Speedway Boulevard?
Hang on a second, we're trying to straighten some of this out. Do we have any idea what's going on?
I do. He's the general manager, and that's the regional manager.
For Mystic Oak South
That's the regional
LLC.
manager for Wing.
We need to be sworn. Is he gonna be part of the case? Okay. Take a brief moment to be sworn.
State your name for the record.
John McKinley,
Can you spell the last name?
McKinley.
All right. Mr. Lovin, you raise your right hand.
Yes, ma'am.
Do you both swear testimony you're about to provide is the truth, whole truth, nothing but the truth?
I do.
Thank you.
I do.
All right, let's start with you, your relationship with Mystic Oak South LLC.
I'm the general manager. I just took over about 7 weeks ago.
All right, well, that works for me. Who's this gentleman?
That's my regional.
Okay,
I'm the regional manager.
very good. All right, let me put the question to both of you. Either one of you can answer me. Does the respondent agree this violation existed or occurred as stated in the notice of violation?
It did previous, yes, sir.
Yes.
All right, then I find the respondent in noncompliance. Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance?
All right, next cutoff, please.
Next cutoff will be September 6, 2023. The city is suggesting these violations ought to be rectified by September 6, 2023. What say you all to that?
Okay, so the people that own the Baymont, they own the Wing House property also. So they're our tenant, we're their tenants. We have fixed the Wing House building. We've put a bunch of money into it. I've got current pictures of all the stuff that's fixed. Like I said, the hotel has nothing to do with the two of us.
If I may provide some clarity, the entire property is owned by Mystic Oak South LLC. The Wing House, they have come into compliance with part of their some of the violations, but the property as a whole, there are still some stuff that are outstanding, as you can
That
see
has
there.
nothing to do with us.
It's the property as a whole.
So if they're in violation, we're in violation, even though we're paying.
Mr. McKellar, if we can, I guess one clarification we need is, are you here on behalf of Mystic Oak?
No, I'm not here I'm just here on behalf of Wing House, not on Mystic Oaks. That has nothing to do with us. We just pay the mortgage and that's it to them. Like
So
I
the
said, I just
property
took over.
owners- I'm
Yeah,
sorry.
we're not the property owners.
No.
I've never even met those people. I don't even know who they are, to be honest.
So it sounds as though the property owner has multiple buildings on this site.
Correct, sir.
This guy might be involved in one of them, but not all of them.
Exactly.
Correct, sir.
So consequently, he doesn't have the authority to speak on behalf of the owner. Okay, is anybody from Mystic Oak South LLC, to your knowledge, sir, going to be appearing this morning?
I've never even met him, sir, to be honest.
How about you? You know if anyone from Mystic Oak South LLC is going to be appearing?
No, sir. I do not know that.
All right, Mr. Inspector, let's back up and go by the numbers. And I don't have a respondent here. So
So,
go through your standard spiel so I can find them in
Sure.
noncompliance, please.
as you wish, this is case number SMG 08-23-200, Mystic Oak South LLC, located at 2721 West International Speedway Boulevard. This was a field-generated complaint on May 9th, 2023, with the following violations: damaged concrete, dirt and grime, potholes in the parking lot, damaged sign, damaged fascia board, damaged exterior walls, damaged dumpster, gate, fenced area, trash and debris, and chip paint. The property was posted on May 17th, 2023, with a compliance date of June 17th, 2023. I've had several conversations with the Wing House management. They have done their part of the violations. However, the property as a whole is still not in compliance. As such, staff is recommending a finding of non-compliance, compliance by the next cutoff. As you can see in the pictures, those are true and accurate depictions of what currently exists on the property, and dates are above stamped.
Okay. All right. Based upon testimony of our inspector, the photographs presented, and the absence of the respondent, I find the respondent in noncompliance. Now, how much time should reasonably be required for the respondent to come into compliance?
Next cutoff?
Next cutoff. Okay. I understand you're a tenant.
Correct. And the pictures there, that's not current. We've put probably about $65,000 to the store already. We've rebuilt both bathrooms. We've put brand new paint around the whole entire building. We've got both the signages all fixed now. We've trimmed the trees, put mulch down. We've put a lot of money into it to get it up to compliance, even though we're not the tenant. Just,
Okay. I don't doubt that, but I'm hearing by way of testimony, there's still things to be done.
right.
So the owner is not fully in compliance
I
yet.
agree. That's an eyesore for our
And
store.
I unfortunately am not privy to the deal between you and your owner to know who's supposed to be doing what.
I 100% agree.
So, but you're here. So I'll ask, since you're here, let's hear from you. How much time, do you have an opinion as to how much time would reasonably be required to bring the rest of the matters into compliance?
Like I said, I'm here to tell the truth. I never even met the people. It's an eyesore for our store because we've just put a bunch of money into our store and they haven't done anything. They've got pods on demand on the side of the building. It's just,
Okay, well, since the two of you showed up, you got anything more you want to add?
no, Your Honor, we just,
And I understand your situation, doesn't have, well,
Right.
it does have
right.
something to
We
do
just
with you.
wanted to make sure we were cleared of that.
You're not even in front of me, right? Whoever you're here on behalf of isn't even in front of me right now.
I got you, 100%.
I mean, I don't mean any disrespect. Technically, it's not
100% agree.
in front of me right now. All right, then I'm going to order the respondent to come into compliance based upon our inspector's testimony. I'm going to order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Now, let me just ask a question, and I don't want to stick my nose where it doesn't belong, but is somebody going to convey to the owner that there's work to be done and a compliance deadline out there?
I can go there when I go into work today. I was supposed to work at 4, so I can go in there before I go to work. Let them know they need.
I just don't want the owner coming back in here saying, we didn't know nothing from nothing.
I can relay the message. I'll be the messenger for you, sir, and tell them that they got to be there by.
Well, they'll get something in the mail. I just want to make sure that we don't get ghosted, so to speak.
Right, or I can get it
By the
paper and
owner,
drop it off there or whatever.
You know, telling me there's some kind of confusion here.
I did get a phone call from an owner indicating that they were going to take care of the property. As of yet, nothing.
Very good, then we'll leave well enough alone and assume it'll all work out.
This was about 3 years ago.
Okay.
Okay. All right. Kim, did I already do everything I'm supposed to do?
Yep.
Okay, very good. Okay, good luck to you.
All right, thank you, sir.
Thank you.
Case number 11, SureGuard Daytona Beach Joint Department PTFL 08741. Not sure what all that is. Anyone here for the respondent? Not seeing a respondent, what say the city?
Certified Inspector Jean-Baptiste with the City of Daytona Beach.
Go ahead.
This was a field-generated case that started on March 17th, 2023, with the following violations: trash and debris, dirt and grime, peeling paint. The property was served certified mail on April 26, 2023, the compliance date of May 26, 2023. A reinspection on August 4th showed the property is not in compliance, as you can see by the pictures. As such, staff is requesting a finding of non-compliance, compliance by the next cutoff.
Any communication with the owner? Based upon our inspector's testimony, noting the absence of a respondent, having considered the photographs presented, I find the respondent in non-compliance and order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 12, TH Daytona Beach 2595 IS LLC.
Present.
All right, who do we have on Zoom?
Christopher Sundez.
Kate Hirsch and Roshan Santhalia, all on behalf of owner.
Very good. Are you all attorneys or part of the ownership or what?
I am an attorney, but the other two are part of ownership.
Okay, Mr. Attorney, you don't need to be sworn, but if anyone else with you is going to be saying anything in the way of testimony at this proceeding, they will need to be sworn, so I'll defer to you. Do you have anybody that needs to be sworn?
I don't think so.
All right, then let's go with you and see how far we get. Do you agree these violations existed or occurred as stated in the notice of violation?
Yes.
All right, then I find the respondent in non-compliance. Let's ask our inspector how much time should reasonably be required to come into compliance. Mr. Inspector?
Next cutoff, please.
The city is suggesting you ought to be able to have these matters fixed by September 6th, 2023, which is our next cutoff. What say you all to that?
Well, we agree with that.
Very good. All right, then, based upon stipulation of counsel, I will order the respondent, stipulation of the parties. I will order the respondent to come into compliance by September 6, 2023, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Very good. Good luck to y'all.
Thank you.
Case number 13, Daytona Commons, LLC. Yes, do we have folks appearing by Zoom?
Yes, Matt, I think they called our case. We just couldn't hear it. We were out in the waiting lobby.
Good morning. Matt Jacobson from Carlton Fields on behalf of case numbers 13 and 14 for respondent Daytona Commons LLC. The owner representative, Harry Spitzer, is also on the Zoom as well.
If Mr. Spitzer is going to be testifying, he'll have to be put under oath.
Sure.
All right, Mr. Spitzer?
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Okay, we have a case number 13 and a case number 14.
Right.
Do they need to be considered separately or jointly?
There are
Very
different
good.
stages, Mr. Vakelji.
Pardon?
I said there are different stages.
I see. Okay, very good. Then with regard to case number 13, Counselor, do you agree these violations existed or occurred as stated in the notice of violation?
Yes, Your Honor.
All right, then I find the respondent in noncompliance. Mr. Inspector?
May I respond further? I understand that all these violations have since been corrected and that my client has been in continual conversations and meetings with the inspector, and evidence of the compliance has been transmitted to the inspector.
All right, slow down. Let me get it. You're getting ahead of me here.
Understood.
All right, Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance on case number 13?
Case number 13 is now in compliance.
Case number 13 is now in compliance.
Sir.
Okay, we have just had an announcement that case number 13 is in compliance
As of
as of
August 4th.
August 4th. All right, so with that, we will now move on to case number 14, Daytona Commons LLC. I assume you gentlemen are here for that one as well?
Correct.
Yes, sir.
All right, this one is here for the imposition of a fine. So this is a different status. So let's hear from our inspector first. Mr. Inspector?
Since last hearing, I've had several communication with Mr. Spitzer, and I visited the property as well. As you can see per my last picture on last Friday, the 4th, work was ongoing, was in the process. I've received an email from Mr. Spitzer indicating that the work is done, but I have yet to have the opportunity to go out to inspect it for myself. So as such, staff is requesting to amend to the next cutoff, please, so I can go out to do the inspection.
All right, the inspector seems to think you might be done, but he needs to go out there and verify it, so he's suggesting we amend your current order of noncompliance to extend your compliance date to September 6th. You got any problem with that?
No, sir, everything has been completed as of this past Friday.
All right, very good. All right, based upon the testimony of our inspector, based upon the testimony of the respondent, I will amend our current order of noncompliance to allow the respondent until September 6, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. All right, good luck, gentlemen.
Thank you, sir.
Your Honor, I just have one quick question, because we were cut off in the beginning. Was this, were these complaints field generated, or were they brought by third-party complainants?
Field generated is what I'm hearing. Did you hear me?
Yeah, I did. Thank you.
All right, good luck to you.
Thank you.
All right, case number 15, Virgil and Ellen Rosenfeld Family Trust. Anyone here for the respondent? Yes.
State your name.
Mike Bretzel.
Raise your hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right, this is here for the imposition of a fine, so let's hear from our inspector first.
Since last hearing, I've had no contact with management for this property. This is an occupied dwelling unit. No progress observed. As such, staff is recommending a fine of $100 to be capped at $20. That was.
I'm sure our past record probably indicates Mr. Bretzel's authority, but if we can just clarify his relationship.
I'm the real estate broker with the property management company.
And you're here on behalf of the
Yes.
trust? Okay.
Okay, so what am I hearing? No work's been done?
Not heard from anyone in the past 2 months.
Okay, let's say Mr. Bretzel.
So the owner of the property passed away, and there were two sisters that inherited it. One sister in Apopka passed away a few months ago, so the mail's been going to her. We just found out about this yesterday. What we do have, the roof has been repaired on the property. We had to start at the top, permit pulled, roof done. Just got the drawings printed yesterday from the architect, the engineer for the work that needs to be done on the back, and John Banks, the builder, has been secured to put in an application for a permit and pull a permit. We have done work inside the property, and the scope of work's done. John Banks, I'm sorry, I just got some notes. If we had 30 days, we could come back and give you an update on what'll be done.
Is there a reason why nobody's communicated any of this to the city of Daytona Beach?
So the sister in California is handicapped, and we've been in contact now with the attorneys for the family trust, and they've got the funds they had to pay the architect, pay for the roof, and they've put the funds aside for John Banks Builders. So it's been, communication has not been strong with the owner because she's handicapped and dealing with the attorney at this point. But we are moving forward. We've since painted the inside of the property. The hallways have all been painted. On the exterior of the property, we haven't been able to do anything until the scope of work was drawn up.
Okay, do the scope of the improvements that you're contemplating cure whatever the violations are that are before us?
Yes, everything.
Do the scope of the improvements you're contemplating go beyond the violations that you're being cited for?
There are going to be some awnings put out front to give the building more appeal. But yeah, everything will be done just the way it needs to be. All the stucco will be repaired, all the wood frame will be repaired, and the painting, all those things will be done.
Okay, and what work are you telling me has been done already?
The roof has been done. Pulled a
Was a
permit.
permit
did the roof.
obtained for that?
Yes, yes, sir.
When was the roof work completed?
I want to say it was probably 8 months ago, maybe a little bit longer. Just in the end of 22, I believe. But like I said, with the other sister passing away that's been handling all this in Apopka, now we're dealing with a handicapped sister in California, and now having to go through her attorney. not capable of making.
When are you expected to resume work at this location?
John Banks is going to apply for the permit maybe later today or first thing tomorrow. He'll put in the application. So it should take about 90 days to work. It's pretty extensive.
Okay, I'm going to continue this item to our September 12th meeting. And if everything that you're telling me comes to pass, then at that point, maybe we can talk about a compliance date.
Thank you.
And you're going to start every sentence with, this place is going to be beautiful when we're done. You're going to be so thankful that you gave us additional time to deal with it.
You will.
Because we pulled it out of the toilet and we made it look magnificent.
You'll see the future picture.
Okay.
Thank you very
Now,
much.
and if I don't hear any of that, then I'll be imposing a fine.
Understood.
Quite frankly, the fine they've suggested, I think, is a little low. So I don't want to threaten you. I'm just telling you that's the lay of the land based on what you're telling me. I'll continue this matter to our September meeting. Hopefully, you'll tell me even more progress has been accomplished. Hopefully, you'll be able to tell me actually when you're going to have a compliance date and how this thing's going to be a jewel for the local neighborhood. And then with that, we'll talk about a compliance date. If I hear anything less than that, then you will be facing the imposition of a fine again as not you, the family will be facing the imposition of a fine as it is right now. Okay?
Mr. Verkelder, with Mr. Bretzel being the agent for the owner, I just asked if he would keep in contact with the inspector, keep the inspector up to what's going on.
Absolutely.
Go a long ways.
All right.
Thank
Good
you.
luck to you.
Thanks.
Case number 16, Daytona Lands 1.
This is another Zoom.
Yes, sir. What is your name?
Fabrizio Lucchese.
And are you here on behalf of Daytona Lands 1?
Yes, I am, sir.
What is your capacity with Daytona Lands 1 that authorizes you to appear on their behalf?
I'm an officer of the company.
Very good. If you would, please state your name to our secretary and be sworn, then we'll proceed.
Certainly.
State your name.
Fabrizio Lucchese.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Okay, this matter is here for the imposition of a fine, so let's hear from our inspector. Mr. Inspector?
Since last hearing, I've had several communication with Dana Spears, the manager for this property. This is an unoccupied property, and clearly there is no longer a property there because it has been demo. However, at this time, we simply need the demo to be inspected and finalized by the city, which I was told is due today. However, since we're here today, we wish to amend to the next cutoff to give them enough time to finalize the permit.
Okay, so what is left to be done to the property now?
Simply need to be finalized by the building department.
So whatever it is I'm looking at doesn't get changed or?
Well, no, there's stand a property before, and it's been demo, and they simply need to go out to say that the demo is complete.
All right. Okay, have you heard what our inspector has to say?
Yes, I have, yes. And actually, the property is going to be graded and sodded. I believe the contractor's doing it today. It was meant to be scheduled last week, but they just didn't get to it. So it'll also be sodded so it'll be green at some point.
Very good. All right, then I assume you're in agreement with the extension that he's proposing?
Yes, I am.
All right, then with the understanding of the parties, I will go ahead and amend our current order of noncompliance to allow the respondent until September 6, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. All right, we have already attended to cases 17, 18, 19, and 20. So that brings us to case number 21, Daytona Center, LLC. Morning.
State your name.
T. Etlinger.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
Yes, ma'am. Your affiliation with Daytona Center, LLC?
Property manager.
All right. Continued from the July hearing, progress report and determination of a compliance date.
Yes, we do have now a sign permit. The sign company was able to obtain a permit. On August 1st, they told me they would need 45 days to complete the sign. So they've ordered everything. They have the permit. We just need to get out there and install it.
What say the city?
We're agreeable to that timeframe. So that would make us to amend it till October deadline. I mean, special mention.
Okay. All right. Based upon the presentation by the respondent and the city's response, I will amend our current order of noncompliance to allow the respondent until October 4, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Very good. Good luck to you.
Thank you.
Case number 22, Victory Temple of God Incorporated. Anyone here for the respondent?
Yes. Hello?
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 Yes, sir.
Yes, sir?
I don't know if I ought to be talking to you or not.
You're going in and out right there, huh?
Yes, sir. If you would please state your name.
Yes, R.T. Hillary, the Victory Temple of God.
All right.
Raise your right hand.
Yes.
Do you
Keep
swear
your
or
left
affirm-
hand on the wheel.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Mr.
Yes.
Thank
Mr.
you.
Kelch, I'd asked if, and I know that we've dealt with this gentleman already, but I would ask that we not proceed until he's stationary. I don't want to be part of anything that may be distracting him as he's driving, if indeed that's what he's doing. It appears he's driving.
Our city attorney recommends that we stop the proceeding until you have a chance to pull over, because we don't want to be partly responsible for all the mayhem you're going to cause out there.
Oh, my goodness. Hold on one second. I'll put it in the shopping center here. Hold on. Okay.
All right. We're here for a progress report. What progress do you have to report?
We got the stuff cleaned up that you asked us to clean up the last time. I got a response back from the city on Thursday. I reached out to the inspector and let him know that they told us by the end of this week they should have a response with their comments and all. And so when I spoke to the inspector, he told me that in the other building, there's a hold on that building there now. And the trash that somebody dropped on our property, I got to get it cleaned up. He told me that on Friday. I haven't had a chance to get it cleaned up since then. But it'll be cleaned up by the end of this week.
Okay, do we have a milestone coming up that I can latch on to that tells me some progress is being made that either of you can tell me about?
I was hoping Mr. Hillary could tell us progress as to his, where he stands with the city and his approval for this development.
Can you hear me?
Yes, I heard him. And that's the site plan review. That's what we're going through. And Ms. Hannah gave a response to our engineer on Thursday that we'll get a response back from them by the end of this week. And so that was the only thing I was able to forward over to them via email that our engineer got back to us. So I have nothing more than that besides what he asked me to do last time, put the tarp on there, close some doors and things like that there, and what he wants me to do, what he mentioned to me on Friday, where they dumped some more trash on the property. I need to get that cleaned up in that other little hole that's on that roof right now. But we have already purchased all the shingles and everything to be able to get going. We just can't do anything until after we get the approval from the city.
And if everything goes smoothly, when do you anticipate site plan approval?
I want it now. So whatever the comments that they have, we just need to know what the new comments are. And then our engineer will be working on them. We just haven't got a response back from them since the last time we met, but they did give us that email saying that they should have the response to those comments that we submitted before we met last time to them back on the end of this week.
And once we have site plan approval, then what?
Once we have site plan approval, we can start the construction to the roof, getting all of that stuff done up and everything, and then everything else that they've approved for us to be able to get done to get inside the building, get the building opened up.
So then, are we allowed to apply for a permit for the roof now, or do you have to wait for site plan approval?
No, we already have the permit. We just can't do anything until we get the site plan approval.
So as soon as you get site plan approval, you intend to start work on the roof?
Yes. We got the shingles and stuff in storage right now.
And you've got the roofer on standby?
And we have the roofers on standby. Now, hopefully they'll be ready to jump in. Storms or whatever come in, we just need to be ready to go.
Okay, let's bring this back for another progress report next month. And
Yes, sir.
hopefully what I'm hearing is we'll have site plan approval and your people will have started at least on the roof. That's
Yes.
what I'm looking forward to seeing. I
Sir,
understand that's subject to change, but what?
well, I would like to request, as it already sent the email to Mr. Hillary, we've got a large pile of debris piled up on the property now. We have another building with a roof that has a hole in it. We would like it to be covered. This is a second building, and we also have some access issues where we need some openings closed up so we don't have transients going in the property.
Okay, we are trying to work with you as far as your objective for this property is concerned, but it's a lot easier for us to work with you as long as we don't have trash on the property, as long as we don't have debris on the property, as long as we don't have openings in the property that make buildings accessible, and as long as we don't have hazards on the property. So I'm scheduling this for a progress report, and I'm asking you to get in touch with the inspector to find out what these interim issues are that you need to be attending to while we keep working on the project itself.
Yes, sir.
Very good. Good luck to you.
Thank you.
All right, and we will schedule this on the September 12, 2023 meeting for another progress report.
Yes, sir.
And he does have the information. I sent him an email with what was requested to be taken care of.
Yes, sir.
Very good. Good luck to you.
All right, thank you. Bye-bye.
Case number 23, 410 Pleasant Street Trust, dated February 21, 2019. Anyone here for the respondent? Not seeing a respondent, what say the city?
Inspector Garcia, credentials on file. I have had no contact at all with the owner. There has been no progress at this time, and there is the property has people living in it still. So with that said, I'd like to get a fine of $100 a day, capped at $15,000.
Okay, these folks were cited for no rental license,
Yes, sir.
and they still have no rental license.
Correct.
And I assume that's because there are all sorts of inspections that will probably precede the issuance of that rental license?
Correct. They also had the grass overgrown, as you can see in the photos. They just recently had it done, but I don't think it was the owner that did it. I think the neighbor next door has been complaining, so she may have something to do with it, or the tenant maybe finally got someone.
And whoever these owners are, they're not communicating with you?
Nope. I haven't even heard from the tenant said that they haven't even heard from the owner.
Based upon the testimony of our inspector, noting the absence of the respondent, and having been presented with the photographs of the state of the property, I am fining the respondent the sum of $100 per day, commencing August 3, 2023, and that fine will continue to accrue each day thereafter until such time as the amount of the fine has reached the sum of $15,000 or the property has come into compliance. Case number 24, Willie Gilmore. Anyone here for the respondent?
morning.
Good morning.
Juliet Parker. Willie Gilmore is my father.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
All right, this matter's here for the imposition of a fine, so let's hear from the city.
Okay, good morning. Sarah Kirk, inspector with the city. My credentials are on file. Since the last meeting, I have had contact with Ms. Juliet. I did a reinspection on August 4th and discovered work without permits. Work was done without permits. The violations are still in noncompliance. So staff is recommending a fine of $100 to a cap of $20,000.
Okay, what say Ms. Parker?
I say that we actually have been working to correct the noncompliance issues. What happened was when she spoke about the work without a permit, we actually went in to do the windows and the shower pan, and we have a windows permit. So what we did was actually, when we took out the shower pan, we found that there was plumbing issues, right? So then now we have to address the plumbing issues. And so while we were in there, we decided to go ahead and paint and do the flooring, which didn't require a permit. But we did already have a windows permit issue. And so then once we got into the removal of the shower pan, we see there's going to be some plumbing issues. So the contractor actually applied for the renovation permit yesterday.
So you have a permit application that's been filed.
And
as I understand what you're telling me, it's to address work that you discovered once you tried doing this work.
Correct.
How much more time do you think you're going to need to get this property in compliance?
30 days will be fine.
30 days.
Mm-hmm. We actually have, the windows are completed. The windows, there was on the non-compliance, the window smoke detector in the shower, and the windows is complete. The smoke detector, Ms. Kirk did advise that there's a smoke detector outside, but we need to have one inside the bedroom.
So, you are just about 2 years into this now. You've started doing some, or you've been doing some work. Along the way, you've discovered that you have more work to do than you anticipated. And after 6 amended orders of noncompliance, you're telling me you're going to have it done within 30 days.
Yes.
Am I hearing you correctly?
That's correct.
And why should I believe you?
Because we actually are already in there, and the only thing that needs to be taken care of is the plumbing. The rest of the part.
I'm not meaning to disparage you. I just don't want to hear you throw 30 days out because you think it's the prudent thing to do. So let me just ask you, do you genuinely believe that within 30 days, all the work you've got left to do is going to be done?
I would say yes, but if you would like to do the 60 days, that would be more, and then we will come in for the 60 days. No, and the reason why I'm
If
saying.
I gave you 60 days, as pleasant as you are, I would never see you again?
Yes.
All right. Who says Christmas can't come early?
And we are.
Okay, just to
Magistrate.
avoid doing a 7th and 8th amended order of noncompliance, I'm going to give you to October 4th.
Okay, thank you.
And if you're back in the same position that you're in now, then I suspect this young lady's probably going to carry the day. As charming as you are, she's pretty charming too, and she might be due that fine she's been asking for, but
Yes, I agree.
we would rather people get their properties fixed and fixed properly. And we understand sometimes things happen.
Yes, and I do.
I just want to say, I just want to make sure, just to clarify that all the work, not just, I think she mentioned just plumbing, there was a lot of other work that was done without permitting, like the exterior, there's HVAC, a lot of work. So all that needs to be in compliance if you're going to allow the 60
You
days.
understand that?
Yes. Okay. I do. And then I don't know if that's said here, but the stairs, air conditioner, I understand it is my dad's property, but that was done prior to me actually coming in and starting to help my dad. So what I understood from my dad when I spoke with him about the stairs, that was done maybe like a year and a half ago or so, and he hired a contractor to actually do that work. And the same thing with the air conditioning unit, the tenants to the store must have placed the air conditioning unit in there without our knowledge.
All right, well, if I'm going to give you this additional time, then I'm just going to ask that you get in touch with our inspector and make sure you have a clear understanding as to what needs to be done.
Yes.
All right. I'm going to amend our current order of noncompliance to allow the respondent until October 4, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. All right, good luck to you.
Thank you. Thank you all.
Case number 25, Xaverius Proprietates Agris LLC. I think we have a corporation of altar boys. Anyone for the respondent? What say the city?
Okay. Since the last hearing, I have not had any contact. There has been no progress. Staff is recommending a fine of $100 a day to a cap of $15,000.
Is property occupied?
It's a rental, I believe so. The last time I went there, though, the vehicles weren't, so I don't know if they recently moved out, but it has been occupied.
And no contact with the owner or the owner?
Since the last hearing, the owners were here the last hearing. They were here, but I haven't had any contact since the hearing.
Wasn't there a problem with, what was the problem with this property? Dispute about maybe a fence?
What it was is like the porch back there. This was a complaint-generated case. The porch back there and the gate, that was all put in without a permit. The owner stated that that's how he purchased the home, that it was already there. That might be what you're remembering. And then also there's no rental license. There was an issue with that as well where they had a short-term, I think they received a fine for short-term rental, and they're only zoned for long-term. So there was an issue with that, but they still haven't gotten a rental license. I believe it failed the rental license, a rental inspection. But that's it.
All right, so what was the fine that you were looking for?
100 to 15,000.
All right, noting the absence of the respondent based upon our inspector's testimony, I'm finding the respondent the sum of $100 per day commencing August 3, 2023. And the fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property has been brought into compliance. Case number 26, AJT Capital Group LLC. Anyone here for the respondent? Not seeing a respondent, what say the city?
Since the last hearing, I have had contact with the property owner. He is, I believe, in Utah, located in Utah. He did have a rental inspection. He wasn't able to get the results from the rental inspection until last week, or I'm sorry, as a matter of fact, yesterday. So he spoke with me, and I told him I would ask to amend to the next cutoff for compliance to give him time.
Okay, based upon our inspector's presentation, I'm going to order that the current order of noncompliance be amended to allow the respondent until September 6, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 27, Waldemar Ruzinski. Yes, ma'am. If you would please state your name and be sworn.
Deanne Yunt, Donardo Property Management.
I'm sorry, say your last name again.
Yunt, Y-O-U-N-T.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
All right, this matter is here for the imposition of a fine, so let's hear from our inspector.
Good morning, John Stenson, Code Inspector with the City. My qualifications are on file. Since the last hearing, I have been in contact with the property owner. They have an eviction hearing scheduled for later on this month, so I'd like to amend this case to the September cutoff to allow them to finish that part of the case.
What say the respondent to that?
I appreciate that. We've been dealing with hostile tenants. They do not respond to us at all.
Very good. All right. Based upon the explanation from our inspector regarding the circumstances and the apparent consent of the respondent's representative, I will order that the current order of noncompliance be amended to allow the respondent until September 6, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Great, thank you so much.
You're welcome.
Thank you. Nice meeting you.
Case number 28, we have already attended to. Case number 29, Lauren and Herb Kawesh.
I get you together.
Yes, sir.
Yes, sir. If you would, gentlemen, if you would please state your names and be sworn.
Herb Cowish.
What's your name?
Stephen Weaver Sr.
Weaver. Raise your right hands.
Yes, ma'am.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Yes, ma'am.
Thank you.
All right, Mr. Inspector, let's hear from you. Why should I find these gentlemen?
All right, since the last hearing, I've had contact in progress. A permit has been issued for the stairs and work has begun. I would like to amend to the November cutoff.
Okay, which one of you wants to speak? All right, Mr. Weaver?
Thank you, Runner. We did get a fence permit, a stair repair permit. Mr. Cowish did retain a surveyor so we could get the exact locations and the elevations so we could have the stairs pre-built. I did get the demolition of the stairs 95% done, and we safed off the area, screwed the doors shut. I've had a subcontractor on site to get a preliminary idea of the scope of work on leveling and raising 515, the other building that's part of the complaint. I believe the owner is attending to some of the more smaller items. And at this time, I believe that the client's intent is to ultimately have me contracted to do all the work with subcontractors. The only thing that's not included in my scope of work right now is a water heater install. Everything else is on my shoulders. And I think by November 1st, we'll have structural plans for the leveling of the other building and a general repairs permit to get all the little stuff done that he doesn't have a handyman. Or I could have just said, we appreciate the November cutoff, almost where we hope to be by that time.
So if everything goes according to Hoyle, from what you're telling me, what is the status of compliance come November 1?
Unfortunately, this was a tenant-brought circumstance with leveling of a building that was done by a prior owner, and until we get the survey that talks about the flood zone elevation and the building department determines whether we need permanent concrete piers and straps versus a mobile home type setup, we're not quite sure on the scope of work. So I honestly wish I could say, but I just can't.
So you're on the job now,
Yes, sir.
and you'll be continuing with the job?
Yes, sir.
All right, then I'm going to bring this matter back to our October meeting. So I will reschedule this matter for our October 10, 2023 meeting. I'm doing so I'm doing so, Mr. Cowish, on the assumption that your contractors and what have you that are present and and at work already are going to continue to do so.
Yes, sir.
Should that change, then obviously my temperament's going to change as well. So as it stands, we will reconvene on October 10, 2023, and I'm assuming at that point, we ought to be able to be pretty accurate as far as determination of a compliance date. All right, good luck to you.
Thank you, sir.
You're welcome.
I'll see you again in a minute, sir.
Case number 30, Andre Rondo and Odette Peralt and Enos LLC. Yes, ma'am, if you would please state your name and be sworn.
My name is Krug.
Spell your last name.
Krug, K-R-U.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
Okay, we are here for the imposition of a fine. It would appear the property is not in compliance as was required by my amended order. Now hold it. Yeah, by my
So, can I talk?
1, 2, 3, 4. Well, let's leave it at that. By my multiple amended orders. So, where do we stand, Mr. Inspector?
Good morning, John Stenson, Code Inspector of the City. Provocations are on file. Since the last hearing, I've received a couple of emails from the property owner. I've inspected the property. My last visit to the property was yesterday. However, the property remains in non-compliance. There are multiple issues that are going to require permits. As far as progress goes, the only thing that has been completed is that a new roof has been installed, and that was finalized on 8/4/23. As of right now, the city is asking for the imposition of a fine of $100 per day to be kept at 50.
Okay, is the roof now fixed?
Yes, sir.
And was that a minor roof job or was that a major roof job?
It was a full roof installation.
Just a second. What now?
They replaced the entire roof.
Okay. All right. Is it Ms. Krug? All right, you've replaced the roof. There's a lot left to be done. Why isn't the rest of it done?
I don't have permit. Mr. Stinson put the stop order there because no permit. I'm waiting for permit. Because this new system, my contractor applied for the window, replace the whole window and the stucco. And for the stucco, and we're waiting for the reviewer. He is on his vacation for 2 weeks. And then come
When
back.
did you submit your permit application?
June 7th, July 10th.
Okay.
So-
And what's the status of that application?
Now it's under review. We just backwards, the same question. My contractor went there to fill out the form to make correction, something, the same question answered 3 times. And then I said, what's wrong? This, some system, he said that his new system, he doesn't use to it or something wrong. But anyway, now it's under review now.
All right, Mr. Inspector, what can you tell me about this permit application that she's alluding to?
She's applied for window permits twice. The first time she applied for it, it required corrections and permits and licensing department sent back, and they had to reapply, and that's what she's referring to.
And these windows are part of what she needs to complete to come into compliance?
Yes, sir.
And do we have any idea what the issues with the windows were?
It has something to do with the application, the windows themselves. I mean, if they're new windows, I don't see the problem. It had to do with the application of the permit.
Some window in violation, they cannot pull up, they don't have screen. But this house is too old. I just replaced the whole new window, just to make it, nicer.
Okay, and do we know when she made this application for the permit?
Oh, window is very long, June 30th, I think.
I don't have that date, but it's been about a month.
Yeah, June 30th, we start a window and a stucco and still not. I have a friend, he said he was 4 months to get the permit. Also, I almost, the building department, they all know me. I went there several times, and I also have the contractor with me go there to make a correction, but they said they packed everything in here. So I cannot do
Okay,
anything.
are the windows the last item she's going to need a permit for?
For the exterior, yes, sir.
Okay, well, I've got exterior staining, damaged roof's moot now, damaged lattice, broken inoperable windows / damaged screens. So I'm getting the impression the windows is a big deal.
Yes, sir. The former tenants that were there. Most of the windows, like she said, are very old. They're wood frame, wood construction. Half of them are painted shut. Some of them don't open at all. Screens are damaged, missing throughout the property.
Who's doing your windows?
Contractor, he do everything.
How much did that roof cost you? How much are these windows going to cost you?
Oh, your window, right?
Well, I did ask about the roof. Now I'm asking about the windows.
Window we purchased from Lowe's, and then he hasn't installed it. We just gave the lots of the whole job together. So I think that cost me, only labor cost me 5,000, 6,000, or 3,000. I cannot remember because we have lots of items, interior renovation and exterior stucco, everything together.
Okay, am I concerned with anything on the interior here?
Interior.
No, sir.
Interior, we apply for renovation twice, they void. And then they said something wrong with the application, but now it's finally August 4th. But not too long, they just put it in system, and it's under review, I think. It's under review, pending or something.
I don't have any current violations for the interior.
Yeah, but because I opened the floor and made the student side, I cannot do anything without permit. That's why I applied for renovation because the wood right there is damaged.
Okay, what is the status of your permit application right now? Is your
Everything.
contractor submitting
Yeah.
more information?
We submitted everything, just everything waiting for approval.
And once he gets the approval, is he ready to go with the windows?
Yes, everything. So, yeah, window I already.
Okay, who's going to be fixing the exterior staining?
The state contract, state land contract.
And who's going to fix the damaged lattice?
Everything is their same company. They have lots of employees. Yeah.
So as soon as you get the green light on the windows, this
Yeah.
contractor's going to take care of everything.
Yes, yeah,
And he's ready to go.
yeah. But he's busy too, But
He's what?
He's busy too. He has a 10 project, lots of projects. But I'm waiting for so long already, more than 2 months. So, but we just need, without permit, Mr. Stinson put a stop order. I cannot do anything now.
Okay, I need you to understand that as far as this violation goes, none of this involves the interior.
Yeah.
So as far as what you're having people work on, this should be the priority.
Yes.
And this is all exterior.
Okay. Yes, I know. But I opened the floor, Mr. Stinson said I cannot work on anything, so that's why I have to put the interior renovation permit. That's the start.
All right, well, again, the interior is not part of this notice of violation. All right. Since you're telling me you made a permit application, and since apparently it's been in the works, and since apparently administratively for some reason it hasn't been issued, I'm going to go ahead and amend the current order of noncompliance to allow you until September 6th to come into compliance or be returned for consideration of a fine of up to $1,000 per day thereafter.
Now-
In other words, I'm going to give you another month or until September 6th to get this done, because I'm hoping your permit gets approved
Yeah,
and your man gets in there and does the work.
Yeah.
And I'm hoping you're going to focus on the exterior and deal with the interior another time.
Okay.
Because the exterior is what you need to get out of here.
Yes, yes, I understand. I completely understand. Just waiting. I check every day. You know, I went there downstairs every day to ask them. They said they're waiting lots of in the queue. That's what I was told.
Okay.
Almost
I mean, you
every-
replaced the roof, so I got to give you credit for that. We just need, and I understand the windows in a house of this age, and I know they're old wood frame windows.
Yeah.
But that's the extent of my construction knowledge right there. I understand the windows can be problematic. All right, so I'm giving you till September 6th to get it all done, and what I want to emphasize to you is, the minute you get the green light to do those windows, you get your window man in there
Yeah, yeah.
and tell him that your special magistrate said this needs to get done.
Okay.
And I'm telling you to focus on the exterior, get these items fixed.
Yes.
Then do whatever you want on the interior.
Thank you. Yes,
Okay.
I understand completely. Just waiting for permit, so I cannot do anything now.
Well, and keep after that permit. You need to get that permit done.
Yes, yes.
All right, good luck to you.
Thank you.
You're welcome.
And also another, can I ask you a question? So because I got this house at the end of May, we evicted the tenants, the only one tenant there. And I have my attorney to evict her. She said, I don't have permit, I don't have rental license, I cannot evict her, I cannot collect rent. I think this is just not right, right? I'm the
I
owner.
don't know what to tell you there. If you want to ask our attorney how all that works, I'm sure he'd be happy to assist you.
Oh my gosh. But anyway, we have to deal with these tennis issues here. During the
Well,
maybe
you bought your way into a tough corner, which is
Yeah, I
evident from the
know.
fact that you're not going anywhere right now. All right, next case, case number 30, 506 North Halifax.
No, this is 207, 209, right?
Okay,
We just did 506.
Okay.
we just did 506. Yes, I'm sorry, we just did 506. Case number 31. All right, now we're talking about 209 Oak Ridge, also here for the imposition of a fine. Again, let's hear from our inspector. What say the city?
Yes, sir. Since the last hearing, I have received email from the property owner. The property has just been vacated. As far as progress is gone, the electrical work was permitted and completed, and that is the extent of the work that has been completed on that particular piece of property. And city is asking for the imposition of a fine of $100 per day to be capped at 15.
Okay, why isn't this one done?
This one, I just got the roof permit. I haven't done because I want to tenants move out. This lady, she's always fight with my worker. I said, okay, after you move out, I have a roofer guy go there to do. That's the whole point. She just moved out by last Sunday. This past Sunday, she just completely moved out. Now there's no tenants there.
Okay, so you had a tenant there that was causing problems, but
Yeah.
that tenant's gone.
Gone, yeah. Now nobody lives there anymore,
So no reason why you can't get this done?
I have to wait for permit. Oh, yeah, the roof, I mean, they can do this coming week. The roof can done, and then the stair, we just apply the permit for stair to fix this stair. And that's it, right? And the window, we apply for window, replace the window. I think that's the violation, right?
So your excuse for not having this work done already is what? That your
Because no-
tenant has been a problem?
No, the tenants always fight with my worker, so after she move out, I will do fix the roof. The stair, they request the stair replace or repair, that need a permit, so we still need waiting for permit.
Okay, when did you buy these properties?
End of the May,
Pardon?
end of the May, I think 26th, May of 26th. 26th of May.
This year?
Yeah, just 2 months. I cannot do anything.
So you've been the owner for 2 months?
Yeah. I just try my best to do, if I can do lots of.
So I don't understand, is the tenant in or is the tenant out of 209 Oak Ridge?
Now, when I bought it, she was there. Now she moved out. There were no tenants.
Okay, so tenant's gone.
Yeah.
How long is it going to take you to come into compliance?
I don't know. It depends on permits. For me, I very fast to do the work. It's ready. Nothing. We cannot do anything without permits now. Just waiting for permits. For window, for this house, we applied for window permits, for the stair permits under the interior renovation.
And as it stands right now, there's no one in this house.
Yeah, no one in this house now.
And you don't know how long it's going to take to bring it into compliance.
It depends on the permits. I don't have any permits except the roof. That's very fast. The roof, that's just 1 week to finish everything. So if without permit, that means no violation involved, right? I can drop the list. Because after I finish everything, I will get it.
Is this property secured?
Yes, sir.
So no one lives there anymore.
Okay, we are going to continue this matter to our September. God darn, I hate to do that. We're going to continue this matter to our October 10, 2023 meeting. You are going to keep going after all the permits you need to get. I'm going to order that property is not to be rented or occupied until it's in compliance.
Yes, I will do that.
And then on October 10th of 2023, we're going to meet again. You're going to give me a progress report as far as what you've accomplished between now and then. And you're going to try to give me a date when you will be done with, first off, bringing this property into compliance with the notice of violation. And then if you want to talk about any additional work you're doing above and beyond that, we will talk about that too.
Yeah, we already applied for interior renovation. So everything is under the pending review, the
Okay.
permits, so we cannot do anything except the roof. The roof.
All right, well, you have stepped into what I would call some problematic properties that are probably about as high profile as you can get. And now, unfortunately, your predecessor has worn out his welcome mat here, but you have only owned the property since May, and you appear to be putting some effort into trying to fix a bad situation. So, enough said. With regard to 209, I want you to continue doing what you have to do to get it into compliance. Continue applying for all the permits. We will talk about this again on October 10th. You will tell me what all progress you've made. And hopefully by then you will also be able to tell me when you expect to be done. All right? And I'm going to reiterate one more time, please take care of the notice of violation items first. If you want to go and do additional work, we're happy to hear it. But once you take the notice of, once you are in compliance with the notice of violation, then we are out of your hair, and you can take as much time as you want doing whatever other improvements you want to do. Okay? So please try to focus on the notice of violation.
I understand. But if without tenants there, I'm trying to renovation everything, interior, exterior, and then I apply rental license into inspection, right? And everything is going up. That's
You're
the
right.
plan. So it's no tenants in 209 now. It's no tenants.
No tenants until the property is in compliance with with this notice of violation.
I know.
Now,
I don't-
when you apply for a rental license, they may require other things, so please don't assume that just taking care of this is going to clear the way for you. They may have their own, I'm sure they will have their own requirements.
Yeah, I know. I already have so many devices.
Well, you've got your work cut out for you. No tenants in 209. Keep the exterior clean
Yeah.
and presentable. And we'll talk about it again on October 10th.
Okay.
Good luck to you. You're welcome. Case number 32, Atlantis of Daytona, LLC.
Morning, Mr. Gelja.
Good morning.
For the record, my name is Steve Alderman, neighborhood code compliance inspector for City of Daytona. My credentials are on file. Since the last hearing, I have had contact. The business is occupied and there has been progress. The front pole sign remains. I have been in contact with Raymond from Kenco Signs, who he's building a fairly large replacement, so he has it scheduled for early October. So I would like to amend this to the October cutoff, please.
All right, based upon our inspector's presentation, I will amend our current order of noncompliance to allow the respondent until October 4, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 33, Stefan Lieb.
Good morning, sir.
Good morning. All right, folks, if you would please state your names and be sworn.
Neville Kaiser.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
We do.
Thank you.
All right, this matter is here for the imposition of a fine, so let's hear from our inspector.
Since last hearing, there has been contact. The business is no longer occupied, and there has been progress. The remaining code non-compliance are overgrown trees, shrubs, and vines, and damaged fence on the south and west sides of the property. The city is recommending a fine of $200 a day to a cap of $25,000.
It doesn't sound like much left to be done.
There's nothing much to be done.
So what's the problem?
The fence itself, we want to make sure that it's our fence because we plan on taking it down. We will no longer have that fence up. Just need a couple
Why
railings.
is it debatable?
Couple railings, excuse me now?
Why is it debatable?
Why is it debatable? Because we don't want to get sued for taking down the neighbor's fence.
Well, I understand that. Okay, do you have a survey showing you where the property line is?
We don't have a survey. We asked the code enforcement guy to help us on that.
Okay. I guess what I'm hearing is the occupier of the property is contesting his responsibility for repairing of the fence. Do we know whose fence it is?
Well, we have spoken about a survey. I did go to the neighboring property that you see, which is on the left side. And by looking at that corner, at least from without a survey, it shows the corner post that goes from around his property is damaged, and from the other side, there's no fence at all. Now, normally, when you put up a fence for common practice applications, if you put up a fence, the good side goes to the outside, and that would be the same thing for his adjoining property to the west. So, without a survey to prove it, still looks like it belongs to the owner of this property.
I want to say, looking like and is being is two different things. I ran a fence company. Normally, the customer could request whichever way they want to have the post to face or the fence to face. So I just want to be sure that we don't take down the fence because I plan on taking it down.
Have we spoken to the neighbor?
Yes.
And what does the neighbor say?
The new manager that was there was not sure, and I have not heard from the business owner. I've stopped there a couple of times, but I've only talked to staff, and they are not sure as far as the property line exact. Now, there is a intake vent that overlaps his property, but and it's on the adjoining building. But from what I could see on previous pictures going way back, that's been there since the building was built.
So what is left to be done? We deal with the fence.
Fence is the largest one left. There is a stored vehicle in the back, and the overgrowth that comes with the fence line, but basically that's it.
So we take care of the fence, we take care of the overgrowth.
Yes. And I believe the Cadillac belongs to the owner.
Yeah, I'm the Cadillac guy.
All right, well, I'm going to give you 30 days, and I either want you to take the fence down or come back with something that proves to me definitively it's not your fence.
I'll do it.
One or the other. I don't care. I'm not going to get stuck in a log jam here. You're not sure. We're not hearing anything from the neighbor. So it doesn't sound to me like there's anybody who gives a rat's rear about this fence, and from the looks of it, I can understand why. So since you're the one that's on the dime here, I'll give you until September 6th to come into compliance or be returned for consideration of a fine of up to $1,000 per day thereafter. And as far as the fence goes, that means you're either going to remove the fence or you're going to come back and say, here you go, Mr. Magistrate, that ain't my fence, once and for all. That work?
I'll do so. Thanks very much.
All right. And it sounds like the only other things that are left are all just small miscellaneous matters.
Yes.
So please get in touch with our inspector so you can make sure you got a clean bill of health.
Thank you very much.
Good luck to you.
Okay.
Thank you.
All right, we've already addressed case 34, case 35, case 36, Joseph P. Torch. Okay, gentlemen, with the exception of not with the exception of Mr. Weaver, you need to be sworn. State your name and be sworn, please.
State your name.
Joseph Torch?
You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
All right, this matter is here for the imposition of a fine. What say our inspector?
All right, since the last hearing, I've had no contact and no progress. I'd like to recommend a fine of $100 a day to a maximum of $10,000.
What's the gripe?
Unpermitted construction. So that whole section you're seeing there is unfortunately unpermitted.
The stairway that I...
The stairway and the addition there where you see the building wrap, that was a balcony.
Okay. And what were you proposing in the way of a fine?
$100 a day to a maximum of $10,000, just simply because I've had no contact.
All right, gentlemen, what say the respondent?
Can I go first? No? Okay. No, sir. My name's Steve Weaver, representing Mr. Torch. Over the last 2 months, I thought Mr. Torch was keeping in touch with Mr. Yates. I've had over 20 emails back and forth with the zoning department regarding this matter, and I've worked extensively with Mr. Urquhart, the building official, on discussions of this matter. Mr. Torch retained a surveyor. Melissa Phillips in the planning department has confirmed that we don't need a variance for the porch enclosure. My architect, James Gilgenbach, is in the process of drawing the plans for the porch enclosure. The stairs, however, we had a surveyor do a comparative overlay analysis, and they're in the exact same footprint as the prior stairs, if not smaller. However, the planning department won't waive the need for a $1,000 3-month variance process. I got that directly from Mr. Dennis Mrozek. I've had some friends in this industry who felt that it was unreasonable to require a variance for steps going back in the exact same location. This week, we've had contact with Cobb Cole regarding potential representation for an unreasonable interpretation of the variance code. Today, we again met with Melissa Phillips to determine what, and to explain Mr. Torch his options at this point. And Melissa Phillips clarified to him that the variance fee is about $1,000. And as of today, he has decided to proceed with the variance despite the fact that we do not believe he should be required to have a variance to put steps back in the exact same location. I apologize for the lack of communication with Mr. Yates. The plans for the enclosure of the addition will not require variance. They're going to be done within 15 to 20 days. The stairs are done except for the top railing, but can't be completed. Mr. Torch, when we got the survey and we gave it to the zoning department, they indicated there was a fence built without a permit, and we've subsequently got a permit for the fence, and he's calling for the final on it. The building official lifted the stop work order and allowed a roof permit, which has been done, completed, and finalized. And so it's really down to the question of whether the stairs need a variance or not. And he's decided to, in my opinion, what I call roll over and take the $1,000 hit in the 3-month delay, as opposed to going to war with the city over a variance fee that is, in my opinion, not appropriate. Sorry about this.
Okay. So is any of this administrative malaise of interest to you?
I mean, absolutely, certainly, it would mean that they were making progress, but it's the same story every time we've been back. There never is any communication. Last time, you yourself said that you would make sure there was communication, or you would do it.
I thought that was on that other.
No, that was this one.
I apologize for that.
Yeah. So, I mean, it's great that they've said all these things. I have no idea if any of these things are true. They've provided none of this to me. So at this point, I am unfortunately unmoved.
We'd like to just request 30 days for him to either get representation with legal counsel or apply for the variance permit.
What is the need for the variance?
It's crazy. The building was built to the front setback and to the side setback, okay? Subsequently, in the last 10 or 15 years, first there was a taking to widen A1A. So the building's past the front property line. And now apparently you're not allowed to put steps in your side yard or in your front yard. And so the man's in a loss. His building is up to the front left corner of the property, and they don't want him to put the stairs in the front or the side setback, and it's dumbfounding. And even the grandfathering of the stairs, they're saying, has anything changed? And Mrozek was even brief and kind of abrupt in his reply. If it's been touched, you need a variance now. And so we disagreed with that, but based upon the cost of getting an attorney versus the cost of rolling over, decided today to roll over, get the variance. So if we did have a
What
chance
was
to come
the
back.
initial citation with regard to the stairs?
The stairs,
3/26/2022.
there isn't anything
But I
wrong.
mean, it was what, failure to obtain permits?
Yeah, he didn't obtain a permit.
He got his permit on the stairs, but the enclosure of the porch is a different matter.
I'm not talking about the porch right now, I'm talking about the stairs.
Stairs had a permit.
Oh, sorry, no, sorry, you're right. He was cited for his dilapidated stairs and balcony.
Okay.
At which point, he started work and ventured into the unpermitted work to do it. He was issued a stop work order, months of delays. We got him to the point of almost fining him about 6 months ago now. He at that point retained this gentleman, and from that point forward, nothing, at least on the building, has moved. And also, he's saying the footprint hasn't changed, but can you go to the next photo, please? Till we get to the front where we're looking at the steps? Right there. As you can see below, that is the original stair footprint. So we can all see that it's changed.
Respectfully.
Can I interject, Your Honor?
Respectfully, there was further steps that went down to the front.
Right.
The exact
So there's-
same location, if not further. We had to build the stairs to current code.
But they have changed. That's my only question.
Changed, absolutely.
Okay, yeah, so the footprint has changed, so they do need the variance. It's very clear why, because even to a layperson, as we can see, if we're saying, have these stairs changed? Well, they used to end where the cement stairs are, and now they end there.
That's
So
negative. The stairs actually went out, and I apologize, Mr. Yates, the stairs went out to beyond where they show on the front as well. They were convoluted. They've got 8, 9, 10-inch risers that are all no handrails. So even if you would have went for a handrail on the old stairs, you would have been required to get this variance under the strict interpretation. We just want 30 days for him to either get an attorney or pull a variance. That's all I'm asking for.
Can I say something, Your Honor?
Sure.
Kevin's right. I did not communicate with him because I assumed I hired a general contractor and he was speaking to the
Planning.
other departments. And my insurance company pulled out of the state of Florida. To this day, I don't have insurance. I went ahead and put the new roof on, and my mortgage company basically is going out to find me insurance. And when the stop work order went on, I can't get my agent to get me insurance. So my focus since I was last here with you was to get the roof done so I could satisfy the mortgage company and that. So I've made considerable progress. The only thing I didn't do was communicate that to Kevin.
And
I
neither
thought
did I.
Steve was doing that for me.
And neither did I.
And then as far as the concrete steps go, there actually used to be a concrete wall. And over the years with the truck shows and the next door Airbnb and all the tourist intrusion into the R1 neighborhood, which is right behind my house, I've been dealing with the intrusion, and my concrete steps went all the way out to A1A. That side is just an alternate step for coming out of your car when you're parked in the driveway. So Steve's absolutely right. They are built in the exact same spot.
We had the surveyor put together a comparative analysis, and it's a smaller footprint.
They're in the exact same spot.
But not the same stairs because the old stairs didn't meet code.
What is the need for the variance? I still don't understand it.
Oh,
That's what
because
we don't
I understand that the variance is required because stairs aren't allowed in the front yard or the side yard. So this man's
Under the
gonna,
new zoning laws.
and he's gonna go into a variance meeting, and if they say no, what's he supposed to do? Not have access to his building? So that's why my recommendation was to hire the attorney, but we got the fees down to 900 for the variance, and we don't know whether it's gonna be successful.
Okay, back up. So the original stairs extended into what is now a setback?
Both of them, the front and the side, yes,
I'm
sir.
13 feet from the A1A sidewalk. The new planning department code is 25 feet. I don't know how I could possibly meet that.
Okay, so, exactly. So you had an old set of stairs that intrude a new setback.
Yes,
Okay, I always thought you were allowed to maintain what was there,
That's what I thought.
and that's what,
but you're not allowed to
That's
replace
what I've
it.
been doing since I started. the project.
I have a multitude of emails with the variance asserting that very fact, that we're allowed to put the stairs back, and although they're not identical, they're identical to the extent they could be to meet current rise, run, handrail codes. And that wasn't good enough for strict interpretation that Mr. Morozek is giving us. And unless we hire an attorney, he's just got to roll over and take it. So, and I do apologize for the communication issue, and I don't want to step away from this. I'm trying to see this through. So,
Mr. Vakelja?
Yeah,
After considering everything, the city would be open to extending to the next cutoff to see what progress they can make, if they can make a serious effort to get this done.
and I can promise that in 30 days, he'll either have an attorney or a
what
variance
used to be there,
application.
concrete steps?
Yes, sir. And there was actually 4 different landings, but
all
there's
convoluted.
all kinds of disagreement with that. But basically, when they widened A1A, they created this hodgepodge of concrete steps and landings. And when Kevin asked me to get a permit, I did. I drew up my drawings for the stairs the way I was gonna rebuild them. It got approved. And I realized that the first 2 concrete steps really wasn't gonna work, so I told you I was gonna update my drawings, and I did, but that never got approved because of the stop work order, and we've been basically in limbo ever since.
It's worth noting that the new apartments across the street are 5 feet from the front property line, but they had the opportunity and the resources to lobby and get commissioners' approval to go way into that front setback, and a $1,000 variance means nothing to them, but it means a lot to this guy.
So I was trying to get my insurance,
30 days.
and I thought that variance fees were
If you say it again, I won't do it.
And
It'll be worth waiting for, sir. It's going to
If
be
you
a
say it
beautiful
again, I'll do
project. I'm sorry, sir.
That's all right.
And if you want to have the picture of the original stairs, just for your own curiosity, if that's what you do.
And if you provide that, I'll provide the comparative
No,
overlay.
Just like I said, just illustrating that they were indeed different. That's all.
They're different is true.
Yes, that's it.
And so the purpose of the variance is to allow you to have those stairs as built.
Yes, sir. And they encroach, the footprint is smaller than the ones they were before. It is different, but smaller.
And what are the extenuating what do we have, like a board of adjustment that hears this?
Yes. No,
It's
but
been too long since my zoning days. And so what do we have, a board of what are the extenuating circumstances that you're going to be presenting to this board of adjustment, which is my understanding is the basis for the relief that you're looking for?
I can explain that. The
Sure.
building is built to or beyond the front setback and to the side setback, and the entry to the house either has to be on the front setback or on the side setback, and in either case, current zoning laws don't allow the stairs to be there. So that's the relief he's looking for, and the extenuating circumstance is the house is built to the front and side setbacks, and there's no place within the front or side buildable area to put stairs without variance.
In the footprint of the parcel.
We haven't enjoyed it
It's
either.
not big enough to build anything. So I agree with what planning department is saying, but unless I demolish the building and add it to my vacant lot behind it, and then I could really build whatever, but I don't want to do that. I don't have the money for that. I just want my steps back.
Yeah, Mr. McKeltry, they're expressing what they believe to be their hardships. I don't have enough detail, and it's pretty much beyond the scope of the code board, but, I mean, this review, the code magistrate, but there would be a board that would review their documents and their information and along with staff, and consider those hardships and make a determination. But I think pursuant to the changes and requirements of the code, right now they're kind of in that stuck position until they either make the options that have been raised, which is either alter to satisfy what the staff feel is the code requirements, or get a
Okay,
variance.
so hypothetically, what happens if the board of adjustment says no?
I guess I got to wreck the building.
Then he's got to take,
I don't foresee this special magistrate telling you to do that.
He would need to remove the unpermitted stairs and the unpermitted work, and the building could stay as is, would be the,
And he would be allowed to maintain, are the original stairs still there?
no, they're gone.
It would be a,
You see that chair sitting there? They would have to be built right where that chair is.
That's-
what it looked like when they were sited. That's the original staircase.
Ms. Magistrate, it would be a
The
quasi.
city has a problem with him replacing that?
Well, no, because
I know, I know.
I mean, I have no input on that part of it.
That's
not.
I was gonna say
That's
there-
way beyond me.
and we asked Mr. Mrozek, planning director, to put it within what other municipalities consider administrative discretion, so he could just wave his hand and say, this is crazy, the rule didn't consider this particular thing, there's no caveat, let him put the stairs up, but he didn't want to go there.
Well, it is a
Mr. McAllister.
quasi-judicial review, and as a quasi-judicial review, it would be appealable if they don't like the outcome, of course. Yes.
Mr. Vicalja, I think a lot of this would not be before you had they got a permit prior to doing all this work. If they had gone in and sat down with the building department and then found out they had certain requirements, instead they went ahead and constructed the steps and did the work on enclosing the balcony without permits.
Mr. Jones, I respectfully disagree. Mr. Torch got a permit for the stairs before he started.
I worked on it for a year.
He then expanded into the unpermitted work, and that's when the notice of violation came. He had an active permit on the stairs, and then somehow or another, after the notice of stop work came, then zoning stuck their 2 cents in and said, no, you can't build them after all, even though he had an actionable permit and was building the stairs to the plans that he submitted. So that's the
When they
serious-
put that pool in next door, the concrete truck and other stuff vibrated the concrete. It was cracking for years. I'm not looking to blame anyone. I just thought I was rebuilding the steps.
And he did have a permit at the time for the stairs. He expanded, he had a permit, I think, for siding.
Well, the south side, the siding was,
Okay, he had a permit to build the steps that I'm looking at right here.
Yes.
He had a permit to repair his steps is what he had.
correct.
Not rebuild new steps, which is what that is. So no, he did not have I mean, let's be fair about it. He did not have a permit for that work. And so that's where we are now. But I think, I mean, as much as I do think it's important to go back in history and look at, where a case came from. I think we're at this point now where the only way, if we're going to give him a way forward, is we need to give him, like he said, at least till the next cutoff to see if he can arrange things to start his appeal to make this a legal alteration.
And we appreciate that and respectively only disagree with one point, which is there was stair drawings that show that stair configuration before he started work. And that's, he made errors and enclosed the porch.
Okay, so right now, what's left that we're fighting over? The stairs and the... what
Getting
is
a
it?
permit,
There's
getting a
there's an
permit for the
addition,
enclosure of the porch.
the enclosure of the porch, but
Separate permit.
that is in the works.
Yes, sir. I'm communicating it.
I'm looking at him.
Not that I am aware of. I don't believe any submissions have been made for that either.
Okay. Well, the only thing I've gleaned from this conversation is that everyone seems to be in agreement that an additional 30 days may be warranted. So I will amend our current order of noncompliance to allow the respondent until September 6, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. I don't understand enough about this situation, so I'm going to keep my opinions to myself. What I will say is, and you by all means go consult with your own attorney, but if this Board of Adjustment says no, I don't know that I agree that's the end of the road. And I don't know that I agree that your only remedy then is to appeal the Board of Adjustment. That's all I'm saying,
It's
because
too
I don't know
complicated
those
for me.
things.
That's too complicated for me, and I can
Well,
promise that I'll
it's too
keep.
complicated for me, and I'm not allowed to run my mouth here. All I'm saying is, this sounds like a mess. It sounds like a good chunk of common sense has flown out the window. It sounds as though miscommunication hasn't helped anything along the way. And I'm also going to order you two to give him everything he needs within the next 48 hours to bring him up to speed as far as what has transpired with this property in front of the Board of Adjustments, the Planning Department, and anything else he needs to know, so he, like I, can perhaps try to understand what the big picture is here. So all that having been said, your current cutoff is now September 6, 2023. I presume that means you have the right to go to the Board of Adjustment if that's your choice. If you choose to do that, then we'll probably have to extend the deadline again to allow you time to have that heard. All I'm saying is whether you go or don't go, whatever their decision may be, I don't know, as far as the purview of my jurisdiction, whether that's the end of it or not. Because at some point, presumably the city would be dragging you back here to say, you need to find these people because. And I don't know what that because is right now. I'm just saying this looks like the kind of administrative headache that probably takes time to sort out.
I'll commit to getting Mr. Yates everything I've got, my transmittal log, and I'll keep him informed from here, and I apologize for my part in not holding up that part of my responsibilities. All right.
No problem. All right, gentlemen, good luck to all of you.
Thank you.
Case number 37, Americano Beach Lodge Resort Condominium.
We're fine. Walking on. Thank you, guys.
You got a problem?
I have no problem. Well, I got tons of problems, but
If
none
you
I
would
can
please
talk.
state your name and be sworn.
Brian Smith, 5601 Windover Drive, Orlando 32819.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I will.
Thank you.
All right, we're here for a progress report to determine a compliance state.
Want to go? Want me to go?
Oh, go ahead.
All right. So, big picture item here before I get into what we're doing with the seawall. So we have submitted a demo permit for the interior of the building. Also, just submitted a minor site plan approval last week, I think. Seawall related, we submitted to DEP. So we're running 2 paths here. So I'm going to repair the broken seawall. So I submitted that to DEP on Monday. I got a contractor pricing, waiting on 2 more bids. So we're going to move forward with replacing that seawall and still continue with designing a full replacement further down the road. But we're going to replace that failed section.
Okay.
I agree with everything he said. That's most of my update as well, is that they've trying to get approval for the repair, but they've submitted all their documentation. I'd like to ask them to come back in November for a further progress report, where hopefully we'll be able to set a timeline for the actual compliance of that wall.
Very good. Everyone seems to be satisfied with the effort. So that having been said, I will reschedule this matter on our November 14, 2023 meeting for another progress report and determination of compliance state. Good luck to you.
Good. Thank you.
Thank you.
We've already done case 38, case number 39, Mohammed Abdullah Al-Zabah. Anyone here for the respondent?
All right, since the last hearing, no progress was made, no contact from the owner. Staff requests a fine of $250 a day with a max of $15,000.
Our respondent is in Kuwait.
I believe so. Recently, he has put the property up for sale. There's some for sale signs out there. I did call real estate company, let them know what was going on, and they said they would try to get in touch with them, but they haven't.
Okay. All right. Based upon our inspector's report, I'm finding the respondent the sum of $250 per day commencing August 3, 2023. And that fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property's been brought into compliance. Case number 40, Issam Hamad. Anyone here for the respondent? Not seeing a respondent, what say the city?
All right, since the last hearing, no progress, no contact. Staff requests a fine of $250 a day with a max of $15,000.
Noting the absence of the respondent, based upon our inspector's report and the photographs presented, I'm finding the respondent the sum of $250 per day commencing August 3, 2023, and continuing each day thereafter until the property is brought into compliance or the amount of the fine has reached the sum of $15,000. Case number 41, Abdullah F.N. Al-Khatami. Anyone here for the respondent? Not seeing a respondent, what say the city?
Since the last hearing, no progress, no contact was made. Staff requests a fine of $250 a day with a max of $15,000.
Based upon our inspector's report, noting the absence of the respondent, based upon the photographs presented, I'm finding the respondent the sum of $250 per day commencing August 3, 2023, and continuing each day thereafter until the amount of the fine has reached the sum of $15,000 or the property's been brought into compliance. Case number 42, Robert and Susie Owens. Anyone here for the respondent? Not seeing a respondent, what say the city?
Since the last hearing, no progress, no contact was made. Staff requests a fine of $250 a day with a max of $15,000.
Based upon our inspector's report, noting the absence of a respondent, and having viewed the photographs presented, I'm finding the respondent the sum of $250 per day commencing August 3, 2023, and the fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property's been brought into compliance. Case number 43, we have already done. Case number 44, William Jones. Anyone here for the respondent? Not seeing a respondent, what say the city?
Since the last hearing, no contact or progress was made. Staff requests a fine of $250 a day with a max of $15,000.
Based upon our inspector's testimony, noting the absence of the respondent, having viewed the photographs presented, I'm finding the respondent the sum of $250 per day commencing August 3, 2023, and the fine will continue to accrue each day thereafter until the property is in compliance or the amount of the fine has reached the sum of $15,000. Case number 46, Abdullah F.N. Al-Khatami. Anyone here for the respondent? Not seeing a respondent, what say the city?
All right, since the last hearing, I've received no contact from the owner, but someone has been cleaning the lot, as you can see. They're not completely done yet, so I would like to amend to the next cutoff to whoever's doing it to finish.
Okay. All right. Based upon our inspector's report, I'm going to amend our current order of noncompliance to allow the respondent until September 6, 2023 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter.
All right, thank you, sir.
That brings us to the lien reviews. Lien Review 1, Brandon Wilson. Yes, sir, if you would please state your name and be sworn.
Brandon Wilson.
Do you swear or confirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Mr. Magistrate, we have met with Mr. Wilson on this lien review, and we would like to recommend reducing the lien to $10,000. And Mr. Wilson has agreed to that.
Is that correct?
That is correct.
All right. And we have a stipulation as to when is that's to be paid, or?
Within the next 30 days.
All right, and we understand that as well.
That's correct.
Okay. All right, well then, based upon the stipulation of the parties, I will agree to reduce the fine and the lien to the sum of $10,000, and upon payment of that, the lien will be satisfied and the fine will be waived.
Thank you. I appreciate it.
And in addition to that, if there's anything else the city needs to do to clear the title to the property, whatever that may be, the city will do that as well.
Okay, thank you very much.
Good luck to you.
Quick question. What's the website I pay this lien on?
I'll reach out to you through the email and give you the invoice.
I really appreciate it. Thank you.
All right, have a good day. Lien Review number 2, Nivra Consulting and Investment Group, LLC, 713 Marion Street.
That will be via Zoom and in person.
Yes, if you would please state your name and be sworn. Both of you.
Dr. Harvin.
Althea Williams.
Raise your right hand. Do you swear, confirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
All right, what was the original notice of violation for? I'm having a little trouble finding it. I'm sure it's just me thumbing my way through this.
Faded paint.
Overgrown landscaping. Is that it?
The original was trash and debris
Brandon
throughout
Wilson,
the
never
property, overgrown grass, hedges, chipped and faded paint. They were first notified back in June of 2015.
Okay. And have the parties discussed any kind of an amicable resolution?
No, sir.
Okay. All right. What's the basis
Hello?
Well,
that I should consider for any relief?
what we're here today is basically get a partial lien release so that we can satisfy the $3,500 on for 520 Dr. Martin Luther King. We were here, I believe, in the last couple of weeks or so, and the amount that was ordered was $3,500, and for it to be taken care of within 90 days. So what we're asking from you today is to have a partial lien release so that we can go ahead and satisfy that according to Florida statute 13.
What was the property upon which the $3,500 was supposed to be paid?
520 Dr.
This is
Martin Luther King.
713 Marion Street.
Yes, this is a separate property.
I understand that. What was the address for the other property?
520 Dr. Martin Luther King Boulevard.
I'm sorry, 520 what?
Dr. Martin Luther King Boulevard.
Okay, so you're telling me that at 520 Martin Luther King Boulevard, there was a lien,
Yes,
and we agreed to reduce it to $3,500,
yes,
subject to being paid within 90 days.
yes.
All right, and now it sounds as though you're trying to explain to me that this is causing some sort of problem over there.
Yes, we're trying.
How's that?
Because we're trying to get that taken care of, because this property right here, 713 Marion Street, is owned by someone else. And it's also going to tax certificate deed sale. That has nothing to do with us. Okay, so.
Us being who?
The representatives of the company that we're consulting with for 520 Dr. Martin.
What's the name of the entity that owns 520?
B. Singh or something. I'm not sure.
But it's a different entity.
Different entity.
Was, what I saw indicated was VJ Singh, who was an investor we had encountered many times in the historic past.
I assume we're not talking about the golfer?
No,
Okay, just thought I'd ask.
I assume. I mean, the same assumption.
Yeah, this property,
was
the
a house.
the MLK property is encumbered because of the lien on the Marion property. I believe the city would probably be in agreement to release, provide a $2,000 reduction on the Marion property to release the MLK property, but still remain on the Marion property for the remainder of the lien.
Back in 20, if, with the information shows, Mr. Vakel, just back in 2018, they came and they made requests for the same circumstance. Now, I believe it was I don't know if the ownership had changed yet or not, I don't recall. But they made the request, and at that time it was denied. It was denied, however, because the property at that time was not in compliance. And I believe since, was there a demolition? Is that what actually took care of everything? I'm
Yes,
not sure, but anyway, ultimately, here we are again. When we did the lien review last month, that just was something they overlooked and did not address. the fact that they were still being cross-encumbered by the existing lien. And so now they're seeking to try and have the reduction for this cross-encumbrance.
It's not a reduction. Hello?
Yes, it's not a reduction that we're asking.
It's not a, yes, it's not, hi, this is out there. It's not a reduction we're seeking. It's just again, a partial release to separate the two so the property can be conveyed. So it's not a reduction. We're not trying to reduce any kind of fees to reduce anything. It's just, again, to separate it so it can be conveyed so it doesn't encumber one another. So I'm trying to get it.
What is your name?
My name is Althea Williams.
And your name?
Dr. Harvin.
Harvin?
Yes.
Is your first name Mr.?
It is.
Okay, well, your whole name is what we're really trying to get a hold of.
Okay,
So
okay.
Dr. Mr. Harvin, is that your name?
Yes.
Okay, thank you.
Okay. What is the name of the entity that got the lien reduction at 520 Martin Luther King Boulevard? Who was the respondent and/or owner?
Never Consulting Investment.
NERVA. So the same entity we have here today.
Yes.
So NERVA owned 520 Martin Luther King Boulevard,
Yes.
and NERVA owns 713 Marion Street.
About
No.
No, not currently.
No.
Not
Who
currently.
owns 713 Marion Street?
VJ. I'm not sure of the exact name that it's under, but VC is the owner. Totally different, separate owner that has it for the
So
last 8 years.
NERVA Consulting and Investment Group LLC does not have any ownership interest in 713 Marion Street.
None whatsoever.
NERVA is here because the liens against a prior owner are still impacting 520 Martin Luther King Boulevard, notwithstanding the, I guess, assumption on your part that when you paid $3,500, you'd have clear title.
Correct.
If I could just clarify one point in that, but yeah, I'll let you finish, Mr. Vocalcha.
I'm done.
Oh, the NERVA was the property owner when the liens were imposed. It was imposed against NERVA, not against this alternative property owner. It was sold, I guess, as is to the new property owner through a quick claim, and that's how the new property owner acquired the circumstance of the existing lien. So just that one clarification.
Yes, and with that, they agreed to assume all the responsibilities and everything else during that time. In other words, releasing the company of any liability at that time through.
Okay, well, more importantly, as far as I'm concerned,
Currently, we don't have any
when we
interest.
discussed the lien against 520 Martin Luther King Boulevard, did anyone happen to mention that NERVA at that time also had a lien against 713 Marion Street?
Nobody. When we got asked about
Because,
that, it was not brought
and
up
I'm just
at
going to
all.
say it like it is, because as the ultimate decision maker, I assumed when you paid $3,500, that meant Martin Luther King Boulevard was out from under any and all liens. It didn't occur to me to ask the question, oh, by the way, are there other liens out there that could possibly impact Martin Luther King Boulevard before I make a decision?
Correct. Exactly.
Came in with a partial request and got a partial result.
We were under the understanding that the 3,500 took care of it.
Okay, has the $3,500 been paid?
Nobody can be.
Nobody can be. No kidding it can be.
No, we were trying
You
to
were
get
supposed
this
to be paid,
within 90 days, yes.
yeah. So have you attempted to make payment?
We're working on the payment right now, but we just
Because heaven forbid, I'm buying myself a pig in a poke here. How long ago was the decision made to reduce that to $3,500?
2 weeks,
2 weeks ago?
within the last 30 days.
Last
The last-
hearings.
the last hearing period.
Last meeting.
Last,
Okay.
To last month, for the most part.
Well, whether it was right, wrong, or indifferent, my impression was for $3,500, Martin Luther King was out from under. I don't know what that translates into, but I guess what I'm saying is if that $3,500 is paid within the 90 days previously allowed, then that will not only remove the lien that was directly imposed against Martin Luther King Boulevard, then that will also remove any liability Martin Luther King Boulevard might have on. Let me ask now, is this the only other lien out there that could impact Martin Luther King Boulevard?
Code enforcement, yes, that's the only code enforcement that we're aware of. Is that correct?
Not that I have to,
Everything's in the book there on the different liens that impose.
I
on
believe
I've got all the
property.
parties here, and I've asked all the questions I'm going to ask.
Yeah,
so-
I believe there may be demolition or like lot clearance, that type of stuff, but as far as the things that we can address in code, for the code board, the code enforcement liens, based on the documents I have here,
Okay.
it appears to be everything, right?
Well, I'm going to treat this as more of a continuation of the previous lien review request, which is only pertinent because the 90 days for payment aren't up yet. And I guess what we have is the respondent now bringing to our attention, there's another lien out there against another property that that 520 Martin Luther King Boulevard would still be subject to. Well, I didn't know that at the time, and I already made a ruling, and I'm not backing up on my ruling. And my ruling presupposed that that meant there would be no more liens that 520 Martin Luther King Boulevard would be subjected to, at least as far as this special magistrate or the Code Enforcement Board was concerned. So, I guess the clarification I'm going to make to the previous order is that upon payment of that $3,500 within the original 90 days as ordered, that 520 Martin Luther King Boulevard will be released from the lien that was imposed directly upon it, and it will also be released from any obligation for the lien at 713 Marion Street. So that is my ruling, because that would have been that was my intent, and for better or worse, I might have overstated it. Pardon?
I have a question.
Thank you.
Does that leave him still on the 713 Marion?
Yeah, I'm
by
not
name?
doing
That's
anything to the
staying.
lien on 713 Marion.
So that's.
I'm just saying Martin Luther King, the lien will not be enforceable. The lien against Marion Street will not be enforceable against 520 Martin Luther King Boulevard, subject to payment.
thank you very much again.
All right. Good luck to you.
Thank you.
You're welcome. All right, is that all we have to bring before the special magistrate? Any miscellaneous business?
I don't have anything.
I don't have anything, sir.
And we got our order out on Indigo,
Yes, sir.
so there you go. We're adjourned.